What happens if you die without a will in Florida? Spoiler alert, your family doesn't just automatically figure it out. I'm Jacqueline Bowden Gold, estate planning attorney here in South Florida with Gold Legacy Law, and in this video, I'll explain exactly what happens when someone dies intestate and why it might not be what you expect. If you pass away without a valid will, it's called dying intestate. In that case, the state of Florida decides who gets your property, not you. The probate court will follow Florida's intestacy laws, which are basically a preset inheritance formula. Your wishes, verbal promises, or handwritten notes don't count. Without a will, Florida law distributes your assets based on your family situation. If you are married with no children, your spouse gets everything. If you are married with children from that marriage only, your spouse still gets everything. If you are married with children from another relationship, your spouse and children will split the estate. This often causes conflict. If you are not married and have children, your kids inherit equally. If you have no kids and no spouse, your parents inherit. If they're gone, it goes to your siblings, then nieces, nephews, etc. If no legal heirs are found, your assets escate to the state of Florida. Here's what does not happen automatically if you die without a will. Your partner, if unmarried, gets nothing by default. Minor children may need a court-appointed guardian for inherited assets. Your assets can be tied up in probate for months or years, your business, pets, or digital assets. With no clear plan or protection, the assets can lose value quickly. Even if you have a will, Florida courts may ignore it if it's missing required signatures or witnesses. It was written under duress or without capacity. It was never updated after a divorce, death, or new child. That's why estate planning isn't just a one-and-done thing. We've seen heartbreaking situations, estranged relatives inheriting everything, long-term partners left with nothing, minor children receiving large sums with no oversight, families forced to sell the family home to divide the estate. All of it could have been avoided with a simple, valid estate plan. Creating a valid will in Florida gives you additional protections, such as 1. It lets you choose who inherits. 2. It allows you to name a guardian for minor children. 3. It appoints someone you trust to manage your estate. And 4. It can keep your family out of court or reduce disputes. For even more protection, especially to avoid probate, consider a revocable living trust. Dying without a will doesn't just leave a mess. It puts the burden on your family during one of the hardest times of their lives. As a Florida estate planning attorney, I make it easy to create a clear, legally valid estate plan so your loved ones are protected. Call us today at 305-556-5209 to get started. Click the link below to schedule a consult. Don't forget to like, comment, and subscribe for more estate planning tips from South Florida's trusted legal team.